Thank you, Assemblymember Wilson. It's a credit to your leadership and your fortitude that a platoon of Assembly members are here, which is unusual. They're not just here because they've got a bill coming up. I think that they're here to support your leadership and your fortitude. Point number one. Point number two is that we are charged, at least my view is, we are charged to affect public policy here in this committee in the legislature. And this committee is unique in the sense that I believe it is our responsibility to craft laws that can be implemented by a court so that the court receives the kind of direction and guidance that we believe is good public policy and when that law should apply. I've heard my colleagues, and you and I have had a discussion about, more than one discussion about this, and I believe that you are of honor, and that we will continue to work to make sure that the bill, as interpreted by the court, will be done in a way that is consistent with your view and our view of public policy. But let me just ask when this applies. So, my understanding is that in terms of any custody dispute, that an agreement between the two parents basically doesn't require a judge to intervene. If parents can agree as to whatever form of custody, so long as it doesn't endanger the child, is appropriate, that will be left alone. The court is not going to intervene when two parents make an agreement as to the appropriate custodial relationships. Is that your understanding?
That's absolutely my understanding. It's only in the case of where any of the laws related to Family Code Section 3011 come into play is when parents do not agree.
Right. So if parents agree, the court need not intervene, number one. Number two is that when two parents don't agree and it requires court intervention, that if the child in question is cisgender, the child in question has no interest in transitioning, has no indication that they wish to transition to another gender, that the court need not engage in that conversation, that issue analysis at all. Is that your understanding?
Absolutely.
All right. So it's only when parents can't agree, only when there's a family dispute between two parents and one child is either wishing to, interested in, or in the process of transitioning, that this would even come into play. Is that your understanding?
Would even potentially be considered just because a child is what we call TGI, trans, gender diverse or intersex. It would only come into play if there was a parent that was antagonistic or anti or non-affirming, and there was one that was. So just being TGI wouldn't even make this into play either. There'd have to be a distinction between the two parents, and that's what the bill does. Makes a distinction.
Right. But in the overwhelming number of cases where parents can't agree, the court needs to intervene,
right,
and the children have no interest in or not in transition, this would not come into play. All right. So we're talking about a very small number of cases, right?
Absolutely.
All right. So then, is it your understanding, actually it's not just your understanding, it's the law that says that the interests of the child are preeminent. When the court makes a decision, it's the health, I believe it's actually in law, it's the health, welfare, and safety of the child that
yes,
is the preeminent concern of the judge.
Yes, absolutely. First and paramount is health, safety, and wellness, or welfare. Mm-hmm.
And the court is in a difficult position to be able to evaluate that based on whatever information the judge has at the time.
Absolutely, yes.
And so in terms of the health, welfare, and safety, as I understand it, that if you have a child, a TGI child, and you have a parent who is not just intolerant, but is antagonistic to that child, that can create an issue as to the child's health, welfare, and safety. Is that right?
It absolutely can. It absolutely can. And we've seen study after study showing that when there is an antagonistic or non-affirming parent, that can create an issue for a child.
All right. I think we've heard some studies. And then secondarily, when there's a family that is supportive, that actually does benefit the child's health, welfare, and safety. Is that your understanding also?
Yes, absolutely.
All right. And so in terms of this law that we're considering today, and it's the sense of the committee this bill is going to pass on, that we will continue to work to make sure that, to Senator Allen's point, that if you have a parent who perhaps has a religious belief that is not consistent with someone wishing to transition, but is unconditionally loving and tolerant, that doesn't preclude that parent from having custodial rights. Is that your understanding also?
Absolutely. And I think with the language that we have, it would say that, but I get that there might be some lack of clarity that some of our senators, who I adore, have concern with. And I think there is opportunity for us to continue that discussion as a part of the legislative process with both you and, of course, Assembly Chair of Judiciary, because it would have to come back to that House as well.
And in the case where parents can't agree, number one. Number two is that there's a child who wishes transition or is in transition, then in that rare case, then the court would take into consideration the parents' attitudes towards the transition.
Absolutely. And as it was noted from some of the testimony and even from some of the discussion amongst the senators here, is that there is an allowance right now for that judicial discretion under the umbrella of health, safety, and welfare of the child. But as we know, judicial discretion, they're human beings as well. And all human beings, I love to say it, are beautifully complex and beautifully imperfect. And so this makes it so that there's consistency and judicial discretion, recognizing that parents' affirmation, which is the exact language, parent affirmation of child's gender identity is in their best interest, versus going to a judge who might determine that that's not in their best interest, and then in the case of a TGI child, rule against the other parent.
And as I understand from our conversation, this is but one of many, many factors that the court is in the rare case where there is a child who would be within the category as defined by this bill. In that instance, the court can take into account this as well as all the other factors that have been both listed and other factors that, for example, finances that the court may think are important. Is that right?
Yes, because looking at the totality of the situation, we expect that a child that is in the family court system is coming for a judge, and a judge has all the information at their disposal brought to them by not only the parents, but other outside agencies that may be involved in the care of that child. And so looking at the totality of information, they are weighing a decision. And so what this bill does is say, as a part of that totality, we want you to add in one more factor. We want to add to, not take away all these other things or abuse or that, but just add to that discussion and make sure it's on the radar of a judge that in a child who is TGI, they need to be seen and their voices are heard, and ensure that they're in an affirming, safe, and a supportive environment.
All right. Thank you. I have no further questions. Would you care to close?
Thank you so much. I will add to just one follow-up that I forgot to mention, is there's been a lot of conversation about taking children away from parents. That happens in a dependence proceeding. It doesn't happen in family court. Family court deals with just disagreements between two parents, and no state removal is involved in that in any way. All parents have a right to see if they're not abusive or anything of that nature, have a right to spend time with their children. But I would like to thank all the senators for the robust discussion. It was great to hear from everyone present talking about this. I would definitely like to thank my witnesses, Jonathan and Melissa, for coming and providing their testimony. I'd also like to thank, of course, my assembly members for coming and showing support. That's how we roll in the assembly, and that's a good thing. And also, every single person that spoke on this bill, whether in support or against, and all those that have submitted testimony in support or against, and every single person that has emailed a senator or assembly member on this bill in support or against, thank you. I appreciate you. I am glad that you are a part of the voices that are speaking to your representatives about what you care about and what concerns you. I appreciate you taking the time not only to communicate, but also to be physically, for those who are physically present, to be here to speak in support or opposition. It is appreciated. That is a part of our democratic process. I would encourage everyone, as always, we can disagree, but as has been said, we don't have to be disagreeable. I am proud to author this legislation. I am proud as a mother, no qualifier, as a mother of a trans child, as a Christian woman, as a leader in my community, as a representative of the 11th District, as a Black woman. I am proud to author this legislation because it is absolutely important that TGI kids are seen in the family court system and seen in a way that affirms them which at the end of the day is affirmation, is about emotional, community, social support. We affirm our children continually. And yes, they're children. They're changing, they're growing. But giving them a safe place to be children and to grow in who they are, recognizing that they are completely separate from you. But at the end of the day, for every single parent, it should be about raising our children to be whole and healthy adults. I was a young mom. I got pregnant very young, and I didn't know what it meant to be a parent. But I remember as I was carrying my child, as I was graduating high school, I knew one thing. That was going to be a whole and healthy child, because I didn't have that. That was going to be a whole and healthy adult, and that was intent. And so with every decision my child came to me with the issues of the world, the cares of the world, that was the focus. That was the focus, that they would be whole and healthy adults. And how could I generate a community, an atmosphere that would allow them to be that? When a child is in a divorced proceeding, it is such an anxious time, not only for the children, but for the parents as well. It is the craziest time ever. And having been a child in that, I know what that feels like from a child point of view. I don't know what it feels like from a parent point of view, and I'm glad about that. But there are so many parents who I've heard from who are just, it's such a crazy time. And I want to say to them that this allows their children to be seen. That's it. It's not saying you're bad or you're good. It just allows, if you have a TGI child, to be seen in a judicial system that says it is a state policy based on scientific research, not just something anecdotal, that affirmation of a child's gender identity is a good thing. To create a safe place for them is a good thing. And it doesn't leave for judicial discretion to say otherwise, because that's what's happening. That is what is currently allowed by law. And having been a Black woman who raised Black sons in California, I love judicial discretionary, but there is some issues, because guess what? They are human beings. And so we want to make sure that they understand that every judge in the state of California recognizes that for a TGI child, affirmation is in their absolute best interest, period. And I will work with Senator Umberg. I will work with Assemblymember Mainsheim, both heads of our judiciary system within our legislative bodies, to make sure that by the time this passes in the Senate and the Assembly and gets to the governor's desk, that it provides the most clarity possible, allowable, without creating a checklist, because nobody wants a checklist. Without being so nuanced, we make it irrelevant, and we make it hard for judges to be able to determine. We allow our judges to have judicial discretion. There's a lot of things that we don't define in this language, but I am definitely open, as I always am on every single one of my bills, and until it gets to the governor's desk, it is open for discussion and amendments. With that, I respectfully ask for your aye vote.
Thank you, Madam